very, very good evening to you. Thank you very much for joining us here on yet another edition of Choice 2017, where we focus on the biggest political conversations ongoing in this particular week. My name is Akisa Wandera. I'll be taking you through the program to 9 p.m. And today we majorly focus on the political parties dispute tribunal that is currently rushing to beat the time to dispense off all the cases that have been presented before them after the just concluded nomination exercise by most of the political parties in this country. But first, let's take a look at just how much power this particular tribunal has with a story from our senior reporter, Patrick Amimo. Has just been taking a look at how things are and the timelines. Remember, 8th should be the last day, but the IEBC says that 4th, which is today, should be the last day. Independent candidates have been rushing against time to ensure that they get it right with the registrar of political parties, party symbols, and all the registration exercises. So it's a bevy of activities from all the officers that are involved in this particular exercise. And joining me tonight is Ibrahim Kira, one of the aspirants who vied for the parliamentary seat of Mosop. Thank you very much for joining us. We also have George Kithi. He is a constitutional lawyer. He will be giving us the legal perspective of everything that has been happening in the country, specifically with the political parties dispute tribunal. Just how far can they go? How much power do they have when decisions have been made by this particular tribunal? Is it the final word? What if parties want to appeal? Any other questions you have, Judge Kithi will be answering that for us. Thank you very much, gentlemen, for coming in. And I think first, as a precursor, before we get into that discussion, let's just take a look at what our senior political reporter worked on. Patrick Amimo will be giving us that. But before we get to Patrick's, I will start with you, Ibrahim. I don't know whether this is the first time you are vying for any political seat, but roughly, how did you find the whole exercise?
Thank you, Akisa. This was my first time to run for political office, and it was a very interesting experience. I started a little bit early to campaign, and I really wanted the best for myself, of course. But it's like swimming, you know. You don't know how deep the water is. You don't know how cold the water is until you get into it. And I want to tell you, it was an experience that I will never forget. It's an experience that I'll always remember. And I know several candidates, aspirants, probably went through the same thing that I went. But I want to tell you, as much as we're talking of tribunals, but people went through stuff. Personally, I will share my experience that it was not an easy process. It was a precarious process, but at the end of it all, you are happy that you did the best for your country.
All right, we'll definitely be coming there to get this personal experiences you had in the nomination exercise. George, today is the 4th. It should be the deadline. Are you seeing any hope of it being extended to the 8th?
Well, 4th is an administrative deadline that was put. It's not a legal deadline. The legal deadline is on 8th when you people should have moved or resigned from political parties. The decision and that liberty is set out until on 8th, as set out in law, and therefore the law has set out liberties which I think, although we appreciate the administrative directive that was given by IEBC, we think liberties that have been given in law should not be constrained, should not be stifled, should not be reduced. So if a liberty in terms of timelines in such an environment has been granted, I do believe IEBC should be flexible enough to do that extension. If it doesn't, I do know that they can be compelled.
So what does this mean specifically for the aspirants who are still waiting with bated breath on the outcome of some of the cases?
That is true. That is true. And that is one thing that IEBC must accommodate. It is not the making of the aspirants. It is circumstances beyond their meat. It is circumstances beyond their control. And therefore, it is beholden upon IEBC, especially where liberty has been provided by law, to allow them to vie as much as possible. Remember, to deny people a chance to exercise their democratic right, including in universal suffrage, to stand in any election is illegal and therefore unconstitutional. And it flies in the face of the very democratic principle which we are trying to uphold. So I think as much as possible, those aspirants must be accommodated. And therefore, it is good to set deadlines early enough so that you can meet your targets as IEBC, but ultimately it is illegal to take away people's liberties, especially if those liberties are assigned and delineated in law.
But would it be in the best interest of political parties for these cases, perhaps, to drag on? Because then, once you reach the deadline, there would be no jumping ship or deciding to go independent. This would definitely work in their favor for them to have their house.
That is true. However, the directives that have been given are such that we have so far exhausted the nominations period. What we have now is the dispute resolution period. It's a phase that complaints then filed with relevant institutions and bodies, and then they're administered. A decision then is made. That's when a person has the liberty to move on, either drop out or move on as independent. Because some of the instances we've seen is complete and total disregard to laid out procedures, legal principle and constitutional framework, and even party constitution frameworks. And because of that, then I think those that feel that they've not gotten justice in the processes that they followed may then opt to try it. And remember, locking out people may be locking out people's choices out there. That liberty by the voter to have as much choice as possible, so that then we can get those that are democratically elected as the will of the people.
Okay. Before we get into more of that, let's just take a look at what our senior reporter, Patrick Amimo, worked on as far as the political parties dispute tribunal is concerned.
The Political Parties Dispute Tribunal is an independent quasi-judicial body with powers to fairly and expeditiously resolve disputes arising from political parties' activities. The tribunal is established under the Political Parties Act and falls under the judiciary. The tribunal is authorized to hear and determine disputes between members of a political party and/or disputes between a member of a political party and a political party. It can also decide on disputes between political parties and/or coalition partners. The tribunal can also adjudicate on disputes between an independent candidate and a political party.
We also have a mandate to hear appeals from decisions made by the political parties, the registrar of political parties.
Since the end of party primaries last week, dissatisfied aspirants have jammed office of major political parties to complain about the process which they claim was not free and fair. Some have even moved to the High Court and filed petitions with the Political Parties Disputes Tribunal seeking to overturn results from the party primaries.
Under our Act, there is a proviso to Section 40, subsection 1 that says that before a party comes before the tribunal, they must try to exhaust the internal party dispute resolution mechanisms so that they are not coming to us as a matter of first instance. They are coming to us after having tried and tested their own party processes. But you know the kind of political parties we have, they tend to be rigid and regimental in the way they approach things, and particularly where you have semblance of a preferred candidate or something like that, the tribunal may not quite do justice to that individual.
Much as individual political parties have their own internal mechanism of resolving disputes in respect to primaries, the final arbiter within the entire process is the Political Parties Tribunal. And the Political Parties Tribunal has an obligation to review it from a more independent and impartial approach.
This week, the tribunal nullified the Party of National Unity primaries in Embu County. It also stopped ODM from declaring Kisumu Senator Professor Anyang' Nyong'o as the winner in the Kisumu County gubernatorial race. We also saw the tribunal direct Wiper Party to issue the Changamwe parliamentary nomination certificate to Peter Mitau. But then, can political parties defy these rulings?
We have cases where parties have come before us and attempted to defy our orders. And like I told you, we are in the nature of a court, so that is called contempt of court. We are also working closely with the IEBC. Any decisions that we make here will be transmitted to the IEBC, and provided that they have not been challenged and set aside by the High Court, the IEBC with whom we have a memorandum of understanding on these matters, is bound to implement those decisions. So anybody who comes here and thinks that they can get away with impunity is cheating themselves.
If parties defy the ruling, then they'll meet the full sanction of the law. The Political Parties Tribunal has mechanisms to enforce its decision. They can find whoever is in disobedience in contempt of court, and they can impose sanctions on the party.
The Constitution allows alternative dispute resolution mechanism. Faced with strict timelines, leaders of major political parties might as well find it prudent to use that approach or risk not fielding candidates in wards and constituencies where aspirants are still wrangling.
Notwithstanding what the tribunal will have ruled, in the event that feuding members within a party have agreed, then the tribunal may record a consent to accommodate the agreement of the parties. It's perfectly in order.
The Political Parties Dispute Tribunal expects to hear various petitions before it until Tuesday next week. IEBC expects to gazette the names of political nominees on Wednesday next week. Patrick Amimo, KTN News, Nairobi.
Patrick, thank you very much for that. We'll take a short commercial break. Coming back, we'll be dissecting that very story done there by Patrick Amimo. So don't go too far. This is Choice 2017.
This is KTN News. This is KTN News.
Welcome back. You are watching Choice 2017. Many thanks for staying with us. With me in studio, Ibrahim Kirwa. He was an aspirant for Mombasa parliamentary seat, as well as George Kithi. He is a constitutional lawyer. Just before we go to George, you said you'd seen a lot of things in the nomination exercise. There have been so many disgruntled voices after the just concluded party primaries. What do you say about the whole process?
I want to believe that the parties did the best they could to make sure that they gave free and fair elections. I think it's the wish of every party, it's the wish of every aspirant to make sure that the elections are free and fair. But I think the system was not ready. In my experience, what I saw, the first time they issued or they brought in the ballots in Mombasa, specifically where I was vying, we ran short of the total amount, number of votes that ballots that was brought in was 20,000 out of 63,000 registered voters. So you look at it and wonder, what did the party, they didn't know that they were missing that much ballots. They didn't know, they were not ready in the first place, but they took precautions and then prepared to make sure that next Monday they were ready. As an aspirant, it puts me in a situation where I just wonder, what else are we not ready? And even then, when we received the second batch of ballots, it was a photocopy, but we accepted and we went with it.
So do you feel like the process was free and fair?
I think as an aspirant, to some extent, yes, but to some extent, I believe that it was not.
Do you feel disenfranchised?
I do feel very disenfranchised, even though I didn't file the motion of complaint, but I still feel that the process that went into place in counting the votes, putting in the system in place to make sure that fairness took place was not there. And that is why you see there is so many complaints from aspirants, because they do feel the same way I do feel that fairness was not done, but we have to move forward. We have to move on. I think that the democracy in Kenya is still growing. I think we are still moving on as a country. And at some point, we'll put systems in place that will guarantee that fairness. But at the moment, we are still way far. And we'll do the best with what we have.
So why didn't you file a complaint? Is it that you don't have confidence in all these other bodies that would be dealing with that issue?
I do believe that the systems that, the tribunal which is put in place will be able to listen to. But I do feel that it will not change anything. I do feel that the results will still remain the same. You'll have used expenses, you'll have used your time, but at the end of the day, really, the final results will remain the same. They will dismiss the case, and we'll end up just where we were at the beginning.
All right, Judge, there are aspirants out there who are trying to beat the timelines to fill forms as independent candidates. There are those whose cases are still with the political parties dispute tribunal. They are waiting for the results. With the IEBC expected to gazette these names next week on Wednesday, and with the number of cases that are yet to be resolved, what does this mean for these particular aspirants?
The legal processes must be allowed to be completed. It's everybody's right. And the cutoff that has been put by IBC is administrative and can always be adjusted to accommodate. And I still feel that when courts are still hearing matters, people cannot be disenfranchised on account of the fact that these are institutions that are put in place in law, and justice will be served only when a decision is made. And therefore compelling parties to make decisions, whereas bodies are still making and running with the cases will not be proper. Suffice it to say that it's IBC responsibility to accommodate even these people at this late hour. More importantly, is that they can still be compelled to gazette and accommodate all these people because they are decisions from courts. And therefore, I still think that IBC is alive to this. I do think that IBC will find a way and mechanisms upon which this can be regulated, can be accommodated, so that there's a proper inclusion of all these people. More so, I don't think the gazettement of certain constituencies, because others are still going on with these disputes, will then render the entire exercise of determination of the candidates null and void. I think it can still be done. It's a reorganization of IEBC that probably will be called upon in the circumstances.
What options do aspirants or even political parties have as far as the decisions that will be made by this particular tribunal? Can they appeal? And if they can,
first and foremost,
how?
IBC duty is not to disenfranchise anybody. And it can't therefore eliminate people on account of the fact that they're being had by courts. And I do think that is something that lies in the minds of IEBC. Administratively, that it's very possible to accommodate these people. More importantly is that political parties must also exercise caution as much as possible so that they be the did. But, even political parties do not have control per se. You see, once a case is before a court, the court will do as much as possible what it behooves it to do in order to accommodate everyone. But eventually, parties have gone before it, a tribunal or court, to be heard. They must be heard. They must be given time upon which to make their representation and presentations. So eventually, you can't commit an injustice just because you want to beat the timelines that have been administratively set by IBC. So I do think that the court have powers to compel the inclusion of these parties and people into the list of IBC as shall be gazetted.
So what are we saying? The gazettement of next week, it could be a tall order?
It will, because even if the gazettement is done, I think it has to be repeated if they proceed as they have said. So I think there's a live threat to IEBC if they proceed with the exercise as they have already set out. So what I think should be done is a revision of those timelines so as much as possible to accommodate the ongoings in courts and the cases that are going on now.
But for the IEBC, they're also under very tight timelines as well. So it's like they're between a rock and hard place, yes?
I think eventually, if IBC pushes with the timelines, they will have to be compelled by courts to do so. And that has happened before. The instances when they have pushed with the timelines, the courts have intervened and forced them to alter that. I don't think they should find themselves there. The clever way to do is to renegotiate on those timelines so that they accommodate the political environment in the country as they see it, as opposed to try to force their way with what they've already planned. Plans are made, but plans can be reconvened so that then everybody everybody is accommodated instead of disenfranchising certain people.
All right. Yes.
I agree with him. I really agree with him because as an aspirant, I feel that you should still be given enough time to make sure that your case is listened to and they arrive at a conclusion that is fair and free to everybody. But if we're going with the timelines and say we have to beat this timeline, that means we'll not be able to give enough time, take enough time to look at the evidence and sufficient evidence to come up with a good conclusion. So I think IEBC should go back and review its timelines to allow the parties to listen to some of these cases and come up with a good conclusion. Otherwise, we'll rush through it. A lot of aspirants will not be happy. Yeah. They will go not happy, and they will either leave the party that they ran with, they'll not be happy with the election, and we end up with a country that people are not happy with the elections.
All right. Gentlemen, we'll have to close it on that. I understand we don't have too much time, but thank you very much for joining us. Ibrahim Kira was an aspirant for